Okay, let's get back to business here if we can. Give everybody a chance to put on their screens. Hello, Pam. All right. Procedures to compel a ruling. And Nina, once again, you're leading the class. So go for it.
Well, thank you. Actually, it's Justice Boyce gets to do a twofer here. So, graciously agreed to lead the charge on this topic.
Oh, that'll be great. The floor is yours.
Thank you, Chip. So to recount the long and winding road that we've been on this topic, this began with a referral based on a letter from Chief Justice Gray identifying issues that he had encountered, and I suspect many appellate judges have encountered in terms of mandamuses filed primarily by persons who are incarcerated trying to get a ruling on a particular motion or suit. The case that Chief Justice Gray was focusing on was a DNA testing request, but the issue would cut more broadly, which is the circumstance that happens frequently is mandamus is filed, but particularly given the circumstances of the incarcerated person, they can't really show that there's been presentment of this motion or request to the trial court and a refusal to rule. And it turns out to be a not very productive exercise. Maybe the mandamus gets dismissed, maybe a response is requested, and then that prompts the ruling, but it's a cumbersome way to proceed. And so the discussion started out from there about whether there would be some kind of a procedure that would be appropriate to either create a presumption of a ruling that would allow a mandamus to proceed, or a presumption of awareness of the motion. And that also sort of morphed into a larger discussion involving civil cases generally, and not limited to just criminal cases involving incarcerated persons, not just civil cases involving incarcerated persons, but civil cases generally, where from time to time difficulties are encountered in getting a ruling, and difficulties are encountered in showing that the request has been presented to the trial judge for purposes of obtaining a mandamus to compel a ruling. Over the course of discussions, the scope of the proposed rule was narrowed by discussion and vote of the full committee, not to encompass criminal matters, not to encompass all civil matters, but to encompass civil actions by incarcerated persons. And so that winding road brings us to page 5 of the memo that was circulated for today's meeting, which basically adapts the prior notice process that was discussed as a proposed rule, but limits it to a particular context. When we got to looking at what was already on the books, it seemed that this really may dovetail with Chapter 14 governing inmate litigation, Chapter 14 of the Civil Practice and Remedies Code, which already contains definitions of claim, contains definitions of an inmate. The scope of the chapter involves cases in which the inmate has filed an affidavit or unsworn declaration of inability to pay costs. It's a fairly narrow area, but obviously one that's significant enough to require legislation to address it. And so the thought was maybe this rule could be made to dovetail with what's already on the books. And so it's basically the same rule proposal that we initially discussed at the last meeting, but with more narrow application. One thing I want to flag for the committee is section 14.014 of the Civil Practice and Remedies Code, part of this chapter dealing with these types of suits by inmates, which says that this chapter may not be modified or repealed by a rule adopted by the Supreme Court. I'm not sure we're modifying the chapter 14, but I want to flag that as something that we should give consideration to in deciding if this is the approach we want to use. I would convey to what I think is the sense of at least part of the subcommittee is that with these narrow guardrails on it, this is a pretty limited rule as it currently is presented to you, dealing with very limited circumstances. There's a lot of absences of ruling that aren't going to get addressed by this. We had a lengthy discussion at the last meeting about whether this was more appropriately addressed by a rule or whether administrative type actions would be better to address it. And the vote ultimately came down on a rule approach, and a rule approach with this narrow focus. There may be other points that other members of the subcommittee want to highlight, but that's kind of where we got to the current proposal that is on page 5 of your memo.
Great, thanks, Bill. Comments, questions? Raise your electronic hand. Unless you think it's perfect. Which, given its proponent, it undoubtedly is. Justice Gray.
I don't know if that proponent was attributed to me or to Bill, but and if it was to me, I make a motion that this proposal be indefinitely tabled because the narrow scope of the proposal as done will achieve none of the benefits for which I have sought a solution.
Well, we'll take a vote on whether or not you're the perfect one or Boyce is. We'll do that later, though. Other comments? Judge Esteves.
Well, I was hoping for a rule, if it was going to be an inmate rule, that after a certain period of time, it would just be denied. Not that somebody can mandamus me or do this extra motion to compel. I don't think that the inmate should have an extra way of forcing me to compel a ruling that all the other litigants wouldn't be able to have. So I would just say that after 60 days that the motion is deemed denied, and then again, I think most of the time the judges aren't even aware of the motions that have been filed in a lot of these cases. And then the other ones are the requests they usually have are not, I won't say all of them, that's not true. There's plenty of them that would be, you need a hearing for, it might be discovery because sometimes the other party may not feel compelled to answer discovery if an inmate's sending it to them. So I have had motions to compel, hearings for motion to compel with inmates. in which they were the prevailing party. So I won't say that they should necessarily have it, or that they necessarily file frivolous motions, but I think that it should just be deemed denied. And then I guess they can file another motion at some other point if they feel like it should be considered, or a motion for reconsideration. But I don't like this as a trial judge who has prisons in its jurisdiction and regularly deals with these issues.
Thank you, Judge. Frank?
Justice Gray, you brought this forward as a proposal for inmate litigation only, as I recall. Am I wrong?
Yes, that would be inaccurate.
Okay. Well, I thought that your concern involved inmate litigation.
It was primarily because of inmate litigation, because the inmate, unlike other civil litigants, does not have the ability to go to the clerk's office, get the clerk or the judge involved directly, or, I rhetorically suggested, what's the inmate supposed to do? Break out of prison, go to the judge's house, show up at his door with a copy of the motion and say, I need a ruling, because that's what we've essentially require is evidence that the motion has been brought to the attention of the judge. And when it is actually my turn to speak and not responding to you, I'll talk about that. But so it was primarily about inmates and their inability to get the evidence necessary to then support a mandamus to merely compel a ruling. It was the background on it.
Well, let me just ask one more question. Are you satisfied that if we limit it to inmate litigation and we make that decision, that the current rule as proposed does that job?
Well, no, because the first thing that got cut out, as Bill said, was all the criminal, and that was probably 60% or more of the rulings that don't get made is in criminal cases. But as to the civil side of it, it might address most of them.
Well, speaking for myself, I like the idea of a special rule for inmates, because the reason you just talked about, they don't have the way to maybe get the court to rule that an ordinary civil litigant does have. I would be very troubled by extending this broadly to all litigation. I guess there is a problem with judges not ruling, and I can certainly see that problem arising with regard to a final judgment, where a judge just sits on a judgment that he should be signing. I'm really concerned, though, about doing it for other types of procedures, most notably summary judgment. I've seen over the years judges do a very good job of carrying a summary judgment to trial and using that to resolve that threat to resolve the case. And if we apply this type of rule to all civil litigation, then I think we're taking a lot of power away from the trial judge. That's all I have.
Justice Gray, it's now your turn to not only respond, but speak substantively.
Thank you. In response to Frank's last comments, nothing would, I don't think, change that dynamic. Remember that you're only doing the, and we've already crossed that bridge, so I'm not going to revisit that. We've already voted against applying it to all civil litigation, all criminal as well. So I won't replow that ground. The deemed denial issue was discussed fairly extensively at the subcommittee level. There are, that Justice Estevez raised, the problem with that is you can really adversely affect the appellate timetable of something if the person is incarcerated and the time, it doesn't know when the time period necessarily starts. Don't know if there's going to be a ruling, and then you get this deemed denial and they're on lockdown and they can't do anything with it for 30 or 60 days. And remember that this only would trigger in those cases when the inmate on a specific motion wanted a ruling to pre-stage a need to do something. And so it's would be fairly limited, I would think, because the inmates that we see here on mandamus, while enough to be a problem, it's not like there's hundreds of them, but they almost always have a specific problem that they need addressed, and they need a ruling before they can proceed to a direct appeal. In answer to Judge Estevez's observation, which I think is 100% accurate, that most trial judges in this situation are completely unaware of the motion on which the inmate wants ruled. I would add in the middle of the proposal, and it literally is right in the middle where it shifts from the what the notice is to the consequences. So right at where the word if is, that when one of these notices is filed, that it is the clerk's duty to provide a copy of the request for ruling and the motion to which it relates to the trial court within 7 days of the filing of the request. That way, the trial judge has a copy of the motion placed on his or her desk, whether that's electronic or paper, it doesn't matter. But at that point, the inmate has advanced the ball, which is what the mandamus cases almost uniformly now strike down as being inadequate to draw the trial court's attention to it. And so the mandamus is summarily denied, frequently without explanation, so that the inmate doesn't even know why his mandamus was denied. But like I said, this has been pared down so narrow to such a small number of cases. I don't know that it's, because the next question we're going to have is where to put this rule. And that's going to create a whole nother series of conversations and needs and pushback. And it's just probably not worth the effort. And I will never ask for another ruling, Nathan. So another rules amendment. So you broke me of that.
Well, we'd love to hear what your comment was, Chief, but you were muted, and perhaps that's a good thing. Who knows?
I said, be careful what you ask for.
Stephen Yelenoski.
Yeah, if this is going to be a rule that just applies to inmates, I think we need to do exactly the opposite of an automatic denial. Because that just encourages judges to never even consider inmate motions, makes it easy. They're often ignored now. That's the problem. And I think that, philosophically, we talk about everybody has a right to be heard, but of course, the circumstances are such, as many have pointed out, that you can't be heard from jail. Or at least you can't as easily be in a position to be heard. And so I think that if we're going to do an exception, it should not be an automatic denial. What we do is we flag those. I mean, in Travis County, what they do now, they flag those and they set them for a phone hearing. Every single inmate claim that comes in. Now, it's possible you do that and you still don't get a ruling, and so you need some backstop for that. But at the very least, the inmate gets heard on the phone. And it may be that their problem is one that they don't understand, needs to be addressed elsewhere. And so they get that kind of advice. So I would want something that makes it possible for inmates to at least assure that a judge has put eyes on whatever it is that they filed, and ideally given them opportunity to literally be heard on it. As for Frank's concerned on the motion for summary judgment, I think that could be taken care of by an exception, either for MSJs, if we're going to apply it to all other civil cases, or just an exception for an order from the judge deferring things until trial, assuming it's summary judgment or anything else. So that's it.
Thank you. Frank.
Well, insofar as Justice Gray's concern about it being overly narrow, as I understand, what we have now is a rule that applies to civil litigation by inmates. That's what we have. And it could be broader, but and that can certainly be tweaked, as Judge Jelinowski has pointed out. There are various ways to do it, but I think we ought to go forward and adopt it. And we've got, it's kind of a laboratory, really. We did this for inmates with regard to unsworn declarations. They couldn't get a notary public, so we let them file unsworn declarations. Nobody else could do it. It worked. Now it applies to everybody. I think we need to do the same thing here. Let's put this in place for civil litigation for inmates and see what happens. We can visit it later. Let's tweak it and fix it, but let's go forward.
Richard Munsinger.
I just want to note my agreement with Judge Jelinowski. I think he's spot on.
Thanks, Richard. Any other comments? All right. If there are no further comments, then I think we have thoroughly discussed this rule, and I think everybody's got a sense of where the various positions are. So we're going to deem this submitted and go on to our next topic, which is compensation for supervised practice. And Nina, tell me where I should send this particular train to, you or to Kenan, or?
I get this one. So.
You get this one, all right.
Lucky me. I have a twofer today.
You tricked me.
All righty. This is, so it's agenda item 7, and the document you should be looking at is D, tab D or item D, on compensation for supervised practice. And this relates to some rules that the court recently re-upped for, I think, in light of COVID and all the implications of that. And the specific issue is in what way do we allow compensation for a qualified, unlicensed law school graduate or, let's see, a supervised attorney, I believe also, under the rules. And the current rule does not allow direct billing by these practitioners. Rather, it must go through the supervising attorney. So the question was, should we look back at that and loosen the reins and allow for direct billing by that attorney, or well, not yet licensed attorney, but practitioner, as long as the bills are countersigned by the supervising attorney. So if you look at the document we provided you, the current rule 9 on compensation is provided there. And we're talking about qualified law students or qualified unlicensed law school graduates. And it says you can get paid, but not for direct billing. You can't do it directly. So it has to be through the supervising attorney. The subcommittee met on whether to loosen the reins here and allow for direct billing under the circumstances outlined by the court. The subcommittee does not recommend that change. I provided in this document some of our concerns. This isn't all of them, but we didn't want to disincentivize close supervision by the supervising attorney. We didn't think the focus should be so much on billing, but on the services provided. And we were unaware of a problem that needed to be fixed. Although I think the reason behind the idea to loosen the reins here would be to expand the pool of supervising attorneys, perhaps make it easier for solos and not, persons not in a law firm situation. I think that was the motivating idea. Jackie or others can maybe help us on that. But anyway, so it's a pretty straightforward request, really, whether we want to allow direct billing by this category of practitioners, as long as the bills are countersigned by the supervising attorney. So that's the question. If there's an interest in looking at that, we have provided some suggested language at the bottom of the page. The new language is in italics.
Great, thanks, Nita. Anybody have any thoughts about whether we should just recommend that the status quo and not try to amend the rule? And once we discuss that, we'll go talk a little bit about the language that's proposed. But any comments about status quo? Versus non-status quo? Nina, you've cowed people into submission.
I doubt it.
Yeah, Lisa Hobbs never, and Judge Wallace, who was falling into the lake the last time I saw him, maybe coming back.
I'll vote for the status quo.
Judge Wallace is a status quo guy. Lisa, what about you?
I don't have much to add besides what, I think Nina tried to articulate, but I don't see a problem, and I see a lot of problems that could arise out of changing the status quo. So I am passionately against changing the rule, but for no more reasons than what the subcommittee has already presented to the group.
All right, Judge Esteves.
More of a question. So right now, can I just ask you, Chip, like in your firm, if you had a clerk there, how do you bill your, I didn't really understand how it's allowed now. Is it just when you review their memo, if you find it's accurate, you can bill your time for looking at it, or do they get to bill, as a legal assistant or something like that? I didn't understand what's allowed now, like in these large law firms, because I'm going to guess the large law firms would love to bill them out at $300 an hour because they're already getting paid more than most of the lawyers are in these really large law firms. So I don't know how I feel about it because I don't really understand what's allowed right now. I've never been in that circumstance where I was aware of how they were billing my time, if they were billing my time before I was a lawyer.
Yeah, I can't speak for all large law firms, but for example, in the summer, you have law students who are typically first or second year law students will spend the summer with you, and they'll work, and billing and getting paid are two different things. But I've never thought that there was a prohibition on including in a bill that I review and send out to a client, having on it the work of a summer law clerk or a paralegal or any other, IT person is doing a document production. There are non-lawyers who find their way onto bills. Now, a lot of clients will say, well, if it's a law clerk, I'm not paying for that. But that's a different question. The bills frequently have non-licensed lawyers on the bills, in my experience. But Nina she's in a big firm. She may have some other thoughts on that.
I would say the same is true for us.
Okay, so then what's the issue? Is this I guess I don't understand what needs to be changed or what's not allowed.
Well, Jackie might want to speak to this, but I guess the feeling was that for let's say you had a solo who wanted to be able to bill directly and not have to go through a law firm mechanism. This might loosen up that requirement and might make it easier for persons not in large law firms. I think that's the basic idea. And to make perhaps, I think, I don't know how it would work, but expand the pool of supervising attorneys. But I'm not sure why it would have that effect. But that Jackie provided us with some commentary by various persons, and that's what we ascertained from the commentary.
Yeah, I think the rule effectively requires the graduate to work at the same firm as the supervising attorney. So Nina couldn't supervise someone outside of Haynes and Boone on a mentoring goodwill basis. And so the question is whether we want to allow for that. Because right now the rule doesn't really sufficiently, the question is whether the rule sufficiently helps graduates who don't have firm jobs.
So a law student, somebody graduates from law school, they've either taken the bar or they're about to take the bar, but there's a period of time where they're not licensed. And so they come to Nina, who's got a big heart, and they say, hey, I'm going to hang out my shingle, so to speak. And I want to get going. You know, I've got some neighbors that got legal problems. And so I want to get going doing it. And, but I want to bill them, but now I can't. So Nina, will you take a look at what I'm doing and look at the bill and send it out? Is that the concept? Is that the idea?
Well, I think the idea would be that the graduate who's hanging up their shingle could send out their own bill just as long as Nina signed off on it. Yeah.
Right. If this proposal is accepted,
Right.
But otherwise they couldn't, right?
Correct. Yes.
Okay. All right. Lisa.
So as a small firm, so I have the big firm experience, and I think my big firm experience is similar to what Chip and Nina have expressed, is that there are unlicensed attorneys' time who gets billed to clients who decide they may or may not pay for it, depending on that. But as partners in those firms, we reviewed the work product, and we of course would never pass off a fee to our client where we didn't think they were getting some substantive value of it, whether they were a licensed attorney or not. So that does happen all the time in a big firm environment, as my experience. Well, that was my experience. I can't say it happens all the time. That was my experience. As a small firm, I've never hired an intern, which I think is kind of what this is, whether a summer associate or an intern, but I do use contract lawyers, and I don't understand why the fact that I would be the one to figure out what my arrangement was between me and this law student or unlicensed lawyer. And then I would take care of billing for them. So I can choose to make them, I mean, they may come to me and be an unpaid intern, or they may come to me and be a paid intern. But ultimately, the obligation to discern whether they added value to a case in a way that makes it a reasonable fee that the client should pay for, that they offered value to that client. I want that to be a decision of a licensed attorney with a fiduciary relationship with their client. And so I don't understand, I don't understand why this would broaden things. I mean, I kind of get the superficial context of like, well, I could bill it myself, but I think the harm that you could do to the system where I had I don't know, like a paralegal billing my clients by themselves without me overseeing it. Like, no, that's not how this works. Like, it's ultimately my obligation as the one with the fiduciary relationship with the client to make sure that everything that I bill them is reasonable and necessary to the provision of legal services to them. And I don't think it's a good policy for the state of Texas to let someone else have that screening process and be able to bill somebody. It just seems like it could just open up a whole can of worms that is just really problem. And the whatever problem is identified here is small enough that I'm just not so concerned about it, that I think I would be, if I were the justices of the Supreme Court, that I would be willing to open up the can of worms that it could open up.
Judge Estevez.
I just agree with Lisa. I think that after hearing why you're doing it, it sounds like what you're trying to do is separate or take off the responsibility from that supervising attorney. And if that supervising attorney has a fiduciary duty, and they should be supervising and also know what these bills are. I know you said they have to sign off on the bill still, so they'd review the bill.
Right.
Then why not just let them send the bill?
Yeah.
You know, I mean, they're doing the same amount of work, and then whatever gets recovered, it seems like you're having the same amount of work anyway. You still had to review the work. I think it creates more problems than it solves, if it's solving any problems. So
Yeah. Go ahead, Nina.
I think the idea is to allow this rule to take place to protect practitioners. That's what I'm calling this other category, unlicensed practitioners, where they can do it outside of a law firm context. So the idea would be that there's no direct client relationship probably between the supervising attorney and the client. So you're in essence allowing more independent practice by this unlicensed person, which has its own bag of problems. But if you wanted to expand that pool and allow this to occur outside of any law firm context, not just a big law firm, but a small law firm, and allow them to be independent practitioners with only a countersigned bill, I think that's the idea here, to loosen those reins, open the pool.
Richard Munzinger. You got to go off mute. Yeah, take your mute off.
Sorry. I think a rule that does not require some kind of a relationship between the certifying attorney and the client weakens the rule against the unauthorized practice of law and creates some ethical problems, possibly, and certainly some, if there's a dispute about it, who is this, the lawyer who is certified that something is reasonable and fair and necessary to the client, but he has no relationship with the client. How can he make such a certification? It doesn't make sense. The rule, if you're going to have non-lawyers bill people for services that they provided that are legal services, they're not licensed to practice law. They shouldn't be doing it. If they do it under the auspices of an attorney who has a fiduciary relationship to the person who is being benefited by the services. That makes sense. Anything that is beyond that does not make sense. Thank you.
Okay, Frank.
Oh, well, as long as we're talking about other context, I'll give you one. I've come across recently two cases that were terribly botched, and the business model was they had one lawyer and 9 paralegals or legal assistants. They did all the work. The clients were ordinary consumers. They didn't know how to deal with lawyers, and they signed lengthy fee agreements when they came in the door. And that's going on now. And to the extent I can see these people hiring a part-time law student and say, hey, now we've got a part-time law student for you to talk to. But essentially, the work is not being done by the lawyer. And to the extent that, or even reviewed by the lawyer in some instances, and to the extent that we could discourage that, I would be for any rule to do that.
Thanks. Alistair.
Yeah, so I guess I'm mostly going to agree with what Richard Munsinger said. You know, at our firm, we allow law students to come in, and we've done it this year because of the delay in taking the bar exam, where they come in and we bill for their time, but because we have obligations to our client, number one, we adjust the billing rate to recognize the fact that they're not licensed. And number two, we review the bills to make sure that the amount of time that they're spending is appropriate for the work that's being done. And we make whatever adjustments need to be made. And the concern that I have is here you've got the unlicensed attorney is billing his or her client. So the supervising attorney has no obligations to that client, has no role in the setting of the billing rate, has no ability to make adjustments to the bills to make sure that they're appropriate and reasonable for the services that are being charged. And so I think it's fraught with danger for abuse, frankly. And so I'm not in favor of the proposed change. I'm sympathetic to the situation involving unlicensed attorneys, but since if they're not going to be affiliated with a firm and the protections that come from that, then I don't favor the rule.
Thanks. Judge Peoples. You got to take your mic off mute, Judge.
I think this shows the wisdom of our usual policy, which is if it ain't broke, don't fix it. There's no proposal out there saying, here's a problem, please fix it. The court asked us to look at it, and we've done that. I've been listening carefully. Maybe 12 or 15 people have spoken, and nobody has really said, there's a problem, let's fix it. And I think this random, unfocused discussion just shows the wisdom of talking about it and moving on.
Thanks, Judge. Chief Justice Hecht, it looked like maybe your hand shot up, not electronically, but actually. Nope. Okay. Anybody else have any comments about this? Jackie, you can get the last word if you want to be a proponent of this ill-conceived thought.
I'm not a proponent. I just, these were some concerns raised by the deans and a few members of the bar when we were looking at these supervised practice rules. So,
yeah, I sort of agree with Justice Dennis that if it's somebody working for you as an intern, as a summer clerk, I mean, you're going to send the bill out. They don't need to send the bill out. And if they're not working for you, you have all the problems that Richard Munsinger just raised about not having an attorney-client relationship with the client of the unlicensed attorney. So I guess maybe I'm in Judge Peoples' camp where this is a solution in search of a problem. So Nina, unless you want to overrule me or anybody else, the chief, or to discuss further, then I think we'll submit this and move on to our next item.
That's great, and it's in accord with what the subcommittee concluded as well.
Okay, so we got that going for us. All right, good. That one's done. So now Texas Rule of Civil Procedure 306A3, and Frank, I see you as the chair of this one.
All right, I'm ready to go if you are.
I'm ready. Let's do it.
Okay.
We're on a roll.
This is item 8 on the agenda. The first item in there is a 6-page memo, but it's double spaced, and you'll need to look at it, particularly pages 2 and 3. I want to begin by telling a story. The other day, in preparation for this presentation, I actually electronically filed my own pleading. I know many of you do that, but I've never done it, and it was an amazing experience. It was hard to get Internet Explorer working because it's a cranky program, but once I did, it was a few clicks, and I had the pleading filed and I had notice given to the other side, all in one fell swoop. There was no pen, there was no paper, there was no envelope, there was no postage, there was no 3-day rule. There was no nothing. Obviously, it's a huge system and really a great system. I know that the people who worked on it back in 2013 probably see all the problems and warts, but from the outside, it's a great thing, and obviously it's the way of the future. It offers, like a lot of the internet, it offers enormous savings in time and energy. And I thought the last discussion about how we bill our time was kind of interesting, and you know, we could have that discussion about electronic filing, but here we're talking about concerns raised by people who don't get paid for their time, and these are the clerks who are public servants and are concerned with the public fisc and the time of their employees. And the focus is on the fact that most of our rules, almost all the rules, were adopted before electronic filing in 2013, and they have some provisions in there that are totally inconsistent with electronic filing or electronic notice. Particularly, there are 4 rule provisions that require the clerk to send notice of a judgment to the parties by first-class mail or their equivalent. These are ones that you're probably largely familiar with. Rule 239A involving default judgments, Rule 165A involving dismissal for want of prosecution, DWOP, one that you may not be too familiar with, 119A involving divorce decrees, and finally Rule 306A, which is the subject of our discussion today. But I'm simply saying this because if we decide to go to electronic notice with regard to 306A, there is almost no reason not to do it with regard to the other rules, and that will probably occur. Now, 306A is a nifty rule. It's 306A 3 says that the clerk has to send out notice of the judgment by first-class mail. If you look on page 2 of your memo, the second indented paragraph, which has a 3 in front of it, that's 306A3. Take out the words electronically. We'll talk about that later. And just imagine it without those words. That's the rule as written. It's mandatory. The clerk has to send out notice of the judgment by first-class mail. The way the rule works is if you can show, if you're the defendant and you can show that within 20 days you did not get that notice and you didn't have actual notice, then you get to postpone the running of your post-judgment timetable. If you've ever used it, it's a neat rule and it works. But again, the problem is sending first-class mail. The obvious question is, should we send notice electronically? And this came from the Joint Committee on Information Technology, and they noted correctly that clerks are already doing this, and they have authority to do this. They have authority under the next rule on page 3, which is Rule 21F10, which says the clerk may send notices, orders, or other communications about the case to a party electronically. There is also at the very top of that page 2, Rule 80 Section 80.002 of the Government Code, which says that a court, justice, judge, or magistrate or clerk may send any notice or document using mail or electronic mail. This section applies to all civil and criminal statutes requiring delivery of notice of a document. Well, the clerks up here, you know, arguably within their rights doing it now. Why not bring the rule into to accord with these provisions and with the current practice of the clerk? And it's insofar as electronic filing, there's no reason not to do it. We can just do it as shown on page 2. Again, the second indented paragraph, just add the words or electronically, and it works. But there's a problem. There are some people who don't file electronically. Here's the current regime. If you're an attorney, you have to file using the electronic filing master maintained by OCA, which means that you file electronically, and you have to provide an email address. A non-lawyer can do that, and he's supposed to provide, he or she's supposed to provide an email address, but they don't have to. Remember, the clerk has to take, if you file a pleading that's an answer to a lawsuit, the clerk has to take it. The clerk can't set it aside and say, oh, wait, you left off an address, you left off an email address. They have to take the pleading. And there are some people who don't use the internet. There are some people who have email addresses but don't file electronically. What do we do with all these people? That's really the problem that we face here. Our initial, we dealt with it at the subcommittee level, our initial response was to say, okay, we'll just put a provision in carving out people who don't file electronically. Look on page 3 of the memo. There's 2 versions there. One carves out people who have not previously filed a document electronically. Another, which is slightly different, carves out people who've not provided an email address. We can quibble over those, but there's a larger question. Should we have a carve out at all? And we had some pushback on our subcommittee, and it seemed to me that they had a good argument. And of course, they're going to get to talk in a second, but let me see if I can summarize it. The problem is that, Sharina Gilliland, who is the clerk's representative on the SCAC and who's very helpful on this, pointed out, look, fellas, if you carve out people who don't file electronically, you're destroying the efficiency of the reform. And the problem is this: how do you know if someone in a file has not filed electronically? How do you know that there's not a pro se answer that was sent to the clerk by paper, scanned, and put in the file? You don't know. You can't go to the OCA or the electronic filing master because they don't keep track of people who don't file electronically. Moreover, the clerks use 2 or 3 versions of case management software. It's not mandated. Ms. Gilliland says, you know, our version that we use in Parker County, which is a pretty up-to-date county, I've been there before, we can't do it. There's no way we can go through that file and immediately tell whether or not there's a pro se party who hasn't filed electronically. I doubt if you're going to be able to do that without redesigning or reprogramming the electronic, the case management system that the clerks use. Well, then why not? Just go ahead and check each one. Well, you got to open the file, you got to look through it, and you got to say, aha, there is a pro se answer. And I'm going to go ahead for those people, I'm going to type up a notice of judgment and send it out by snail mail. That's the problem. Moreover, there was some question as to really, and this is kind of a cost-benefit analysis. It's kind of a junior version of the enormous questions that we dealt with on termination cases earlier. How many people are we talking about? And are we is the cost, and under a cost-benefit analysis, is it really worthwhile to jam the whole system so that these people get notice of the default judgment? Initially, I like most of you, my default position is due process, and I said, wait a minute, we can't do that. But wait a minute, we're talking about an enormous saving to the taxpayer, and let me give you some statistics. Last year, there were 42,000 judgments signed in Texas. First class mail postage is 55 cents. And if we assume that we send one first class mail for each one of these cases, that's about only $23,000, but it is taxpayers' money. And, you know, clerks are funny about taxpayers' money. They like to save it. There's also, I think, larger savings involved with time and energy. So, you know, this is the way of the future. Are we going to let a few people stand in the way who don't file electronically of progress? Well, how many people are we talking about? Let me give you, I couldn't find any answers on that. It would really be helpful to know how many pro se litigants there are in Texas who don't file electronically. But I can't imagine that there would be a way to figure that out in the whole 254 counties that we have. I did find some nifty statistics from something called the National Telecommunications Information Administration. I don't know whether that's a government agency or not. And they said that in these statistics are all for 2019, 79% of Americans over age 3, I don't know how they came up with that number, over age 3 have used the internet. Now there are some variations, as you might expect. Certain ethnicities or minorities have less, 4 to 7% less. Also, as you might expect, there's an income disparity. People where family income is below 25,000, only 62% have access to the internet. Excuse me, 65%, and where it's over 100,000, 87%. And finally, people 65 or over, about 68%. Well, okay, those statistics. How does that translate into how many people file pro se answers without filing electronically? There's no way to tell, but I suspect, but this is just a guess, that it's much longer, much lower, excuse me. The question then, and I think the question that we decided on the subcommittee to present to the full committee, because it's an important question, is do we have a carve out at all? Once we make that decision, and if you say we have a carve out, we can draw one up real easy. It's no problem, and it won't be any problem to extend it to these other rules, although that may fall to other subcommittees. There will be problems, certain problems with each rule. For example, DWOP notices under Rule 165A are sent out in bulk. Well, we're not talking about searching one case. We're maybe searching 30 cases to make sure that there are no pro se answers for the people who haven't filed electronically. And finally, with regard to default judgments, the people who don't even know they've been sued, are we gonna leave them out? Are we gonna not send electronic notice? I'm not sending paper notice to them. There is one further thing. The fact is that people who don't get notice do have remedies. First of all, the first rule is Rule 306A. You get extra time if you can show that you didn't get notice in time. You don't have a restricted appeal because you can't show error on the face of the record, but your fallback position is the bill review. And there are cases that do say that if people don't get notice their judgment, that they can get a bill of review. So that's pretty much the controversy in a nutshell. I think, Chip, I'll turn it back to you, but I think I'd like to hear, or maybe you'd like to hear from members of the subcommittee on this point. Let me add one thing more. Even if the subcommittee had not disagreed, I still think we would bring this issue to the full committee because it's that significant. Thanks.
Great summary. Although I think that must be a bigger nut than we typically think of as being a small nutshell. But
okay.
All right. Great summary of the problem. Who has comments? We'll wait a second while people get their electronic hand. Roger.
Well, I favor some sort of change on this because I live in an area where the courts are being a little schizophrenic. I have one county that remained nameless, and they will email you the notice and they will email you the final judgment. because they can. I have another county where they will absolutely positively refuse to electronically send you the final order of dismissal or judgment. Instead, you get a letter and telling you that if you want a copy, send us $1 on a page plus the cost of mailing. Even though you can go online and download a copy from the clerk's office. I don't understand that. I think it ought to be available. The clerk ought to have the option to send it to you electronically, just to end the madness and lower the expense. I will say this, I think there is a problem with pro se litigants because they may have an email address, but there's nothing in the record that will tell you what it is. They may have called the court coordinator and given them an email address, and things will be sent to them, but nothing in the record will show that that's a good email address. I even had one case where the lawyer withdrew and the court started sending notices to the now pro se plaintiff by email. And after summary judgment, 6 months later, up popped what we used to call them writ of error, now I call them accelerated appeals or whatever. And there was nothing in the clerk's record to show that the email address to which all this stuff had been sent to the pro se plaintiff was a good email address. So the case, the summary judgment had to be reversed without the litigant ever certifying that they hadn't gotten it. The question on the accelerated appeal was, can you prove it in the record? So I would also suggest consideration of some official record being made or allowed to be made that either someone who filed pro se or became pro se during the course, what their email address is, so that we don't have the problem that they're getting stuff, but we can't prove it because even if there's something showing the court sent it to that email address, there's no proof linking that email address with the litigant. That's my 2 cents worth.
Thank you, Roger. This is a small point, but if the clerk doesn't have an email address for the litigant, how are they going to serve the judgment? I mean, they would have to default to first-class mail, wouldn't they? I would think. Frank?
Well, unless we said they didn't have to. They of course would have an automatic access to Rule 306 to Rule 306A, because you have to show that you either didn't have actual notice or didn't get the notice from the clerk, and they didn't get notice for the clerk. Yes, that's a real problem. And we don't know how many people we're talking about. I mean, you could think about maybe it's some isolated person out in the sticks like the Unabomber, and maybe so, but and it is true, in fact, that there are a lot of people that you wouldn't expect to have email addresses that have email addresses. For example, homeless people go into the public library all the time and check their emails. So again, we just don't have any handle on that. The one further thing, in terms of what Roger said, and Sharina Gilliland pointed out this in her memo, which is in the materials, and it would be helpful for y'all to read that. She said, look, why send notice? Why not just send the judgment itself? You're sending it electronically. Yes, it's 150 pages, but it's electronic. The requirement of notice was given back when you had to send it by mail. You don't have to now. So you could certainly make the system operate more efficiently then. But if we don't do anything, if we leave it there, I predict the clerks are going to continue to send it out electronically. That's just what's happening. It's too big a savings, and there is support in the rule and the statutes for them to do it. That's all I have.
Thank you. Professor Carlson.
Yeah, I just wanted to mention that 30684 only gives protection for 90 days. If the litigant didn't, or their attorney didn't have notice or knowledge of the judgment, but they do receive it within 90 days. After that, if you receive notice after the 91st day, the Texas Supreme Court has said the rule does not help a litigant, doesn't extend the time for post-judgment motions or the time to appeal, but you still have, as Frank pointed out, the equitable bill of review avenue. And I wanted to echo what Frank said. I think it would, if we're going to move in the direction of giving electronic notice of the signing of a judgment or appealable order, it ought to include the actual judgment or appealable order, because it is not, I don't think, overly burdensome for the clerks to send that along with it. That's all I have.
Thanks, Elaine. Judge Wallace. Judge Wallace.
There's a category of cases, your default judgments, where you're almost certainly not going to have an email address, and all you're going to have is a physical address. So I think, at least as to default judgments, if you don't send out a first-class mail to that address, then you may as well just say that in default judgment cases, they're not entitled to notice, because that's the only way you got to give them notice. But that could be a carve out, I would think, where you obviously you'd have to send them by first-class mail.
Yeah, thanks, Judge. Stephen.
Yeah, let me ask a question first. I was confused, Frank, you said that there's no way for the clerk to tell if a pro se litigant had filed electronically, is that right?
No, there is a way to tell. Well, I don't know. I presume that there is a way to tell if a pro se litigant has filed electronically, but it doesn't make any difference. If you send out notice electronically to everybody who has filed electronically, you're going to pick up the pro se litigants who have filed electronically. The problem,
right. But you're not going to follow up with an email, because you just assume everybody got, or they're not entitled to. If
there's a halfway point there. There are a number of people who provide their email. And in fact, the rules say that you have to, the statute says you have to provide your email address, although people don't do it. But there's a problem there. And I think this is, and that's this. Just because I have filed, if I filed a paper pleading and included my email address, I'm not watching my email. I mean, we are all lawyers. We know to look when we see no reply on our email. We know to look at that. People who are not filing electronically, who've been filing by paper, even though they provided an email address, will not know to look for that.
Well, but that's that problem is easier to understand why it would be incumbent on them to check email if they have it. Now, putting aside that there are people who don't check email, those who have email, in my experience, check it several times a day. And some people just start to ignore their first class mail because it's all junk. But the part I'm getting to is if the clerk sends out notice through the electronic system, are they going to know if they also have an email address to send it to?
I don't know that.
Okay, because
certainly they can research the file to determine if that person has provided an email address. And,
right.
And also, just as a sidelight on what Judge Wallace was talking about, if we do a default judgment, you have to file a certificate of last known address. You could include an email address in there. But one more thing, and that's this. You and I may move at different circumstances, but I know a whole lot of people who don't check their email.
More power to them. But it seems to me that we've got to give I think, it's fine to give electronic notice, but if it turns out the person has not filed electronically, then that's a problem. And so we either need to be if you can't determine, but you have their email address, you can send it to the email. I think it's their problem to check it or not. They gave you the email address. The converse is, why are you asking for their email address if you're not going to use it when you give notice of a judgment? So I don't know. I mean, is there a savings from just saying we're going to send all these notices electronically, and if we don't know, we'll send it by email, or we'll send it electronically and by email? How does the clerk deal with that as a practical matter?
Well, the clerk under all the proposals will have a choice. Right now, the clerk has to send it by first class mail, but the clerk will have the option to send by email. As it turns out, as Sharina Gilliland's memo points out, there are clerks in some small counties that prefer regular mail.
Well, I think they should have all those options. I guess I was getting at, I thought you were saying that some people are going to fall through the cracks, and that's the price we pay for efficiency. And if you mean by the fall through the cracks that they will, they'll still get an email, whether they look at it or not, then I'm fine with that. They've provided the email address and ought to know they should be checking it if in fact they're involved in a suit. But I wouldn't want somebody who neither files electronically nor gives you an email address to not get mail. And so I think everybody needs to get notice, and all those options, certainly electronic, should be available. I was going to point out, but it's already been pointed out, the 306A is only 90 days. And after that, you're out of luck on that. I don't think these backstops, if we're talking about pro se litigants, talking about the backstops doesn't really help. Hopefully, if they get notice of the judgment, they'll do something with it or not. They're not going to be aware of 306A. Final point is just that when I looked at all this material earlier, it seems to me that, and this would be a bigger project, but perhaps not, or a broader project, but perhaps not a bigger one. The whole thing on notice of judgment is confusing because of the way it's structured. And I think you could easily move things around, but there's a lot of places where it doesn't signal clearly that it's talking about notices from the clerk at all. 21 says electronic filing, and then way down under F is electronic filing. Way under 10, it talks about notice from the clerk and orders. Doesn't say judgments there, but even regardless, it's talking about electronic filing. Then you get into 306A, and 306A says periods to run from signing of judgment. But way down in there somewhere is the notice requirement. So under 3. So to me, this should be reorganized and relabeled. That's a bigger issue.
Yeah, let me say this. I disagree with you on one point. I think when if we're going to give paper notice to people who haven't filed, who merely filed a paper response and haven't provided their email, I think we ought to also give paper notice to people who have filed and provided an email address but haven't filed electronically. You know, like I say, I know to look for my email and know that I'm to look at no reply. That means I've probably been served. People don't know that. They don't know that from it's somebody in Kazakhstan trying to get to know them better. I mean, there's no way that people are going to, a lot of people are going to check their email with the thoroughness that this requires. Let me give you one further bit of information you need to have, and that's this. Apparently, the court, or at least OCA, looked at this question back in 2013 when Rule 21F was promulgated. And if you'll look over on page 5 of the memo, you see the original version of the provision involving clerk notice, and it's applied only to parties who file documents electronically. That was the original version, which I think was adopted in June or July of 2013. But when the final deal went down in December of 2013, they took that out and they simply put the current provision, which we talked about earlier, which says the clerk may send notices, orders, or other communications about the case to a party electronically. I don't know. It would be helpful to know what lay behind that decision. Was it a technological problem, or did the court decide we don't need to send notices? We're going to send all notices electronically. We don't have that information, but it would be helpful.
Well, Frank, if somebody if the clerk has the person's email address, then they've gotten it somehow from that person, correct?
Yes.
So
or maybe they've gotten it from the opponent.
Okay, well, that's an issue, certainly. But if they get it from the individual, it certainly could, when they're served, because they're going to have to be served initially if they're the defendant, we could easily put in there a notice that please provide your email address and you'll receive all further communication through the email address.
That would help.
Yeah, I mean, that's what everybody else does now in the private world. You know, you essentially consent to notice electronically. Everything's moving that way. And so I don't know the answer to your problem. If they got the email address from the plaintiff, maybe there's some other way to fix that. But it doesn't seem to me that once the person knows, either by giving their email address to the court or knows that the other side has given an email address and confirms that it's correct, that we should worry at all whether they're checking their email. Because once they know that, and with some other advice or notice about it, they should check for this particular email. And like some entities do when they send you email, they say to make sure you include us in your contacts so it doesn't go to spam. I mean, all of that's moving towards there. So if you set it up right, I'm not really concerned about sending something to a person's email address.
And what you're saying, I think, is suggesting that we amend the form of citation.
Maybe so.
Cherie's been waiting patiently for about an hour.
Thank you. I really like the language proposal just to add or electronically. I think I would interpret that as a clerk. If I have an electronic means to get somebody notice, I can use that. If I don't, then I should be sending them first class mail of that. That's how I would read it if you just said first class mail or electronically. I think the broader or electronically is better than specifying the electronic case filing system or email. As Frank mentioned, each county decides what kind of case management system that they want. Some are more sophisticated than others. And it would allow county by county, if you want to use the e-filing system, you could. If your case management system could gather up all those emails and massively send them out, it would allow you to do that and just give some flexibility in terms of what could come with case management systems and utilizing electronic addresses. And Frank mentioned this too. I would love to see, instead of just notice, if the clerk actually gave you an electronic copy of the order or judgment, that satisfies notice. It doesn't need to be a separate notice. Just to CYA, we prepare a separate notice that says final judgment or order. And then if you want a copy, we can get you a copy. But we're in our office, we're already e-filing every single signed order and judgment to the parties and going through the e-file system. So if we already just give them a copy of that signed order, I think that should satisfy that notice requirement. With respect to default judgments, those may be somewhat more unique and somewhat different because we haven't had any contact from that defendant. And so maybe that should remain just by paper, but at least maybe think about any electronic options if that's appropriate. But I do like, from the clerk's perspective, if you just leave it more broadly electronically, that allows county by county to utilize whatever electronic means they have to fulfill that requirement.
Great, thank you. Lisa?
Okay, I might be the contrarian view here. And I appreciate the clerk's office perspective, of course. But we're only talking about final or appealable judgments, and put aside that even sometimes I don't know what is an appealable judgment or not, and I'm board certified in appellate law. But I think, and we also sometimes don't know when something's a final judgment. So I was about to say we don't, but if something's marked final judgment, the magnitude of that moment deserves something different. And I think that we should cautiously, apart from all the practical problems that have been raised here today, I think we should be mindful of the significance of the moment of a final or appealable order, but mostly a final judgment. Because I think the law is developing that sometimes appealable orders, like even though they are appealable at that moment, you won't lose your rights if you don't appeal it at that moment. But for sure, final judgments, whenever possible, it should be, hey, this is not going to an old Gmail account. This is actually going to your residence, much like the start of the lawsuit is not just going to a Gmail account. We're doing something different with all the other orders that you've gotten to say, hey, this order, this judgment, this is actually affects your rights in a big way. So I get it, to counteract Frank's story about him getting on e-filing, in this, when the appellate courts lost their means really in a lot of ways to communicate it with us effectively over the early part of this pandemic, the Supreme Court started, when you get a notice from the Supreme Court, which is where I practice most often, you actually get a notice that comes from a different email address. It's not from it doesn't look like my service copies that the other side is filing to me. It comes in, I don't know, some other way that I'm like, oh, whoa, Supreme Court's communicating with me. What are they saying? I gotta know. But in this period of pandemic, when they didn't have full access to the TAME system, they basically had the clerk serve me like orders and notices, just like as if it were the other party serving me something. And not that I don't take every service completely seriously, but in that scheme and in that chaos of, March, April, May, the Supreme Court had ordered full briefing on a case where I was the petitioner and I missed it. I just didn't get it. That's not the way I'm used to getting notices. And that's no fault of their own, but that's just the point of even seasoned lawyers and even seasoned, sometimes you need additional notice when you're like, this is actually really important. So I wouldn't change it. Even as somebody who e-files all the time and gets my notices from courts mostly electronically, I still think that final judgment should be mailed to me personally as a lawyer who participates in the e-filing system on behalf of my clients. I want to get the first class notice of an actual final judgment. I also, just for the record, I do not think these clerks have authority to be doing anything differently. I think the specific controls over the general and the fact that they think that they can be mailing final judgments out without doing it by first class mail is completely wrong, and they don't have the authority to do it. There's some ambiguity. I get some ambiguity in that, but I think 306A3 is pretty specific. So if any clerk wants my legal advice on that, you do not have the authority to be doing it otherwise until we change the rule. So that's it.
Great. Stephen. You got to take yourself off mute, Stephen.
Yeah, I know. I was just trying to find the button. I guess we're in a transition phase regarding first class mail. And we're also we're pro se litigants, I think, are in a different situation than a lawyer sitting in the office. You look at all your mail, or somebody looks at all of your mail. You send something to a pro se litigant, it's less likely, at least they're not going to be as rigorous in checking their mail. Maybe they don't check the email, but that doesn't mean they look at every piece of paper that's coming through first class. And so, like I said, maybe it's a transitional thing, but I wouldn't assume that people still pay more attention to their paper mail than they do to their email. And we know, as a matter of policy, the post office seems to be less and less equipped to deliver mail, and that's perhaps going to change. But in any event, I think it's transitional, and so maybe at least it's too early now. I don't know, but it seems to me to be changing.
All right, thanks, Steve. Frank, it looks to me like we have 4 options in front of us. One, the Hobbesian choice of no change. 2, just adding the 2 words or electronically, the Gillian proposal, or they've previously filed a document electronically, and the 4th choice, a party hasn't provided an email address.
I think so.
Is that how you see it, Frank?
Yes, that's how I see it.
Okay. Well,
Although,
I
think we would probably maybe go in a different order. I think we first need to say, are we going to allow the clerks to give electronic notice? And then the next question is, do we carve out, if we allow them to give electronic notice, do we carve out people who either haven't filed electronically or haven't provided their email address? And with regard to that last one, should we change the citation in Rule 99? That might be something we talk about. Finally, the last issue, I think everybody agrees on this. If we allow electronic notice, we should allow the clerk to send the judgment instead of the notice. That would be the kind of the super savings there.
Okay. Well, it seems to me that the threshold issue is whether the committee votes to make a change at all.
Yeah. Do we accept the JCIT recommendation or do we reject it?
Well, that's a loaded way of saying it, but
okay.
Lisa says, I don't want to make a change. So that position is going to get 1 vote unless she changes her mind. But why don't we take a vote on that threshold issue first, okay? So everybody that thinks that we should not make a change, raise your hand electronically, please. Well, it did get 1 vote, got 2 votes, 3. Keep coming. 4, 5. Anybody else?
Chairman Babcock, I would like to point out that these are some of the most esteemed members of our committee, myself excluded.
Well, Shanken voted, he's got his hand up. Are you including him?
Lisa's right about that, but before I vote, I think I need my notice by mail.
We're holding steady at 5 esteemed members. Everybody's esteemed. Pauline, do you have any more than 5?
I have 5, but I wanted to point out that Nina had her hand raised before you started the vote. So I'm not sure if she had a comment or if it's an actual vote.
Good point. Nina, comment or vote?
I'm just, for all the reasons that have been said, and I don't mean to overly complicate, I would actually provide for service both ways. I think this is so important. And for reasons said, there's mail issues as well as email issues. This is an important deadline for people to be apprised of. So I would provide for both types of service, provided that the electronic information is available. But I would not let go of the mail option, the mail requirement.
For anyone, right?
All right.
Correct.
So you're taking down your electronic hand on what we're voting for, which is no change in the rule. Okay.
And if I could maybe clarify what the Hobbesian position is, that's kind of my position too. So maybe I thought no change, but I'm not opposed to also sending me electronic notice. I just want the mail notice too. So maybe I've derailed this in a.
No, I don't think you did, because if you want to mandate mail notice, then you're going to say no change, right?
Well, no, but what we're saying is and that wasn't an option before, and that's why I voted for no change, is because I do think there should be by mail. I don't disagree with that. I would just add electronic if available, but I wouldn't take away mail. Sorry.
I agree with that too.
All right. And
so do I. So do I. That's why I voted the way I did.
Okay. All right.
So I think the way to interpret that vote from, I think now all 5 of us who voted that way, not that it matters because it's just 5, but I think what we're saying is we're not opposed to electronic service, but we just don't want to take away the mail service. And it sounds like that was the consensus of everybody who raised their hand for quote unquote no change.
Okay.
Yeah.
We got it. Take your electronic hands down. So now there is a proposal to just add the words or electronically and not have a carve out, as Frank calls it. This would be the language that would be on page 2 of the memo. How many people are in favor of that? Raise your electronic hand.
Can you give us a minute to find page 2?
Yeah, sure. Take your time.
I just want to clarify. This one would be if they electronically filed, then they get it by electronically. They get an electronic notice, and if they were a pro se or they have that address and a certificate of service, then they would get their service or their notice by mail.
No.
Okay.
No, the language on page 2.
Sorry.
No, that's okay. The language on page 2 gives the clerk the option to either send it by first class mail or electronically. It is silent about whether they have the address, whether anybody's filed electronically. It's just 2 words that are being added.
Okay. I think that would give the same effect because obviously if they don't have an email, they can't send it to them. So they'll have a way of, if they had a way to give them notice, they would have to do one or the other, correct?
I don't know. Okay, Pauline, how many do you have there?
Well, 15 now.
Okay. Well, I just saw another one, so.
That's 16.
Yeah. Anybody else? 17. Anybody else? Okay, Pauline, I've got 17 votes.
Yes, 17.
Okay. So that has 17 votes in favor. How many people think we should have a carve out, one or the other of the 2 carve outs? Okay, everybody done?
Chip, can you clarify what's the vote you're asking for right now?
Whether there should be a carve out. There's 2 options, but right now we're just going to say whether you think we should have one or the other of the options, and then we'll vote on who thinks what is the best option.
Chip, are you talking about the language on page 3?
I am.
Okay.
Yes. That's what Frank refers to as the carve-outs.
That's correct.
Okay, everybody voted? I got 9, Pauline. How about you?
I show 9.
Okay. Now, of the 2 carve-outs, regardless of how you voted previously, do you like carve-out number 1, which is the first carve-out on page 3 that talks about if a party had not previously filed a document electronically? Everybody in favor of that carve-out as opposed to the other one, raise your hand. Everybody done? Up here's another one. Pauline, I got 4.
4.
Okay.
I think I'm another one too, Chip, if we're allowing people to vote if you hate where we're going with this, but you still want a say in it, then I would be on that one too.
Okay, so that's 5. And so the second carve out, how many people are in favor of that? Everybody voted? Pauline, I've got 9. Well,
I'm
maybe-
showing 10. Hold on, 1.
Yeah, one just added. Yeah, since I said that, 10.
Looks like 11 now.
Okay. Count that again. Up, there we go. All right, Evan came in at 11. All right, got it. So 11 for that, for the second carve out. So recapping, 9 people, 9 members of committee think there should be no change. 17 like just leaving it, adding 2 words or electronically. But if we're going to have a carve out, the second proposal, the proposed carve out, which says, but if a party has not provided an email address, then notice must be given by first class mail. That is preferred over the other carve out by a vote of 11-5. So how about that for some voting, huh?
Very good, Chip.
I have a friendly suggestion for further
Who's-
study. It's
who-
Roger.
Who wants to suggest something?
Roger Hughes.
Okay, Roger, you may be, hang on. There you are. Got
Yeah.
it.
Okay. My suggestion is if people are worried about notice, that we consider that the clerks have to mail it out with blue backs.
And then we'll take our exam.
Yeah.
Wow. Frank, we'll take that under advisement,
Yeah,
Roger. if
okay.
That's all right. Frank, you want to exceed the scope of the inquiry and change Rule 99?
I think so. I think if we're going to go with the second carve out, then I
Yeah.
think, or even the first carve, let me say this. I think you probably ought to change Rule 99 in any event to let people know that they can file electronically, because there will be people who do it and people who don't read the rule book. And if you decide, you can put further language in there, but I think it's a good idea and I know it's kind of radical to mess with Rule 99, but I think this warrants it for everybody. you can file electronically, and if so, then this is how you do it.
Okay, Professor Carlson.
Yeah, I would also suggest, Frank, you take a look at Rule 57, which deals with signing of pleadings and imposes right now an obligation of counsel and a party not represented to provide an email address.
Yes, yes, we do cite that in the memo on a footnote.
Okay.
Okay.
Right, and you're that could certainly be in Rule 99 that you know, what you've got to provide in the answer. You've got to provide an address. If you have an email, you've got to provide it. And by the way, you can also file electronically.
Great. Harvey.
We vote on Lisa's suggestion that notice should be sent by both mail and email when it's available.
We didn't vote on that because I didn't perceive Lisa as advocating that, but maybe she was.
I thought she was, and I thought Nina seconded it.
That's correct.
Yeah, I'm in a voting kind of mood. How many people are in favor of requiring the clerk to send both first-class mail and electronically? Raise your hand, electronic hand.
Chuck, can I comment on that?
I figured you would. I was waiting for you to dive in on that.
Okay, that's just not practical. It's just not. When you're dealing with volume, even right now, there's no case management system that keeps track when you open up your case, who filed electronically and who filed in paper. Maybe you can dig through the e-file manager and be able to tell. So any efficiency with electronically is completely lost if you have to research and figure out who filed which way. Requiring both is a little over the top, I think.
Hey, don't worry, you're winning.
Okay.
Only 7 people are.
It's a bit much, and any efficiencies are completely lost at that point. Particularly when you get to your DWAP docket, if you want to go in that direction, because of the volume, it's just overkill.
Yeah, don't worry. There's only 7 people who have their
Okay.
hands raised on that one. So
I wouldn't be doing my fellow clerks justice if I didn't say, please don't go that way.
I was shocked that you didn't, start pounding the screen when that came up. So we're good, and we're at a stopping point, I think, for our lunch break. And so why don't we come back at 1:30? Does that work for everybody? That'll give you about 50 minutes for lunch. Okay, we'll be in recess until 1:30. Thanks, everybody.